Thank you, Mr. Chair and Committee, for the opportunity to speak in favor of House Bill 1536. My name is Fread Houston. I'm from Austin, Texas. I formerly served as the Director of Sanctions for HHSC Office of Inspector General from January 2009 to May of 2012, and I'm speaking in my personal capacity. The fact that the OIG has a responsibility to pursue fraud, waste, and abuse in the Medicaid program is not in question, I think, from the perspective of many of the people here. I think that the concern is that any agency that has an enforcement approach that's appropriate should make sure that it's competent, ethical, in comport with due process, and have an awareness and sensitivity of the program's purpose and its intent. The current OIG management, despite a lot of the politeness that was presented in the process, has charted an extremely aggressive course in its recoveries. And they have the right to do so. That is their discretion to do so. However, I think it becomes a problem when that aggressive course is not supported by a focus on the fundamentals of building a case and making sure that you're developing it adequately and making sure that you're following due process, and instead you're relying upon target goals for the amount of funds that you can collect and bring into the agency, and novel reinterpretations of policy that instead of proper evidence and enforcement of the Medicaid rules, it becomes more of an issue of how much is the dollar amount that we can bring in. I have a number of concerns that developed over the time that I was at OIG. One that continues is a matter of the type of experts that they bring in. There wasn't a clear vetting process for how they picked their experts, and most of the experts that came in had little, if any, experience with Medicaid, assuming that they were even Medicaid providers at all. And so from the attorney's point of view, that makes your case a little bit more difficult when you're taking on those types of issues and you have experts that don't even have the background and the experience that you would expect to adequately support the case and the experience to make a Medicaid interpretation based upon what they were being asked to review. One of the other concerns that we had was that the normal intake processes for reviewing cases for legal and evidentiary sufficiency for the determination to initiate prosecution were effectively removed from the attorneys in the Sanctions Division who are legally and professionally responsible for those prosecutions. And this was the case such that it resided almost entirely in the hands of the deputies, and in particular the Deputy of Enforcement, who directly oversees the Medicaid Program Integrity Division, which is where the investigators are also housed, and he controls their investigations going forward. Payment hold cases, which were transferred directly to Sanctions under the credible allegation of fraud process, and the payment hold was mandated to be put in place immediately. Under the orthodontic initiative, the agency retroactively applied a new Medicaid policy interpretation regarding ectopic eruptions and declared past orthodontic treatment to be fraud or willful misrepresentation under the new credible allegation of fraud mandate. This strategy would allow the agency to impose a 100% payment hold on all Medicaid practices based upon their reinterpretation of a policy with no actual evidence of fraud, despite recent claims by the OIG management made to the legislature with regard to extensive vetting of the case process. The very questioning of any evidentiary sufficiency of a case by legal staff was met with swift disapproval by the IG, the Director of Enforcement, and the Chief Counsel. The discretion to consider any good cause exceptions, including financial burden, was limited to the discretion of the deputies themselves, instead of the standard process, which was in place when I was there, of sending any type of recommendation for a good cause exception based upon financial issues to the Sanctions Division accountant, who would typically perform an independent review of the provider's financials and issue her recommendation. The actual evidentiary case itself could take years to complete investigation, and even a payment hold hearing could take 8 months or more before a decision is issued. And the payment hold, in that case, remains in effect during that entire time. This process could easily destroy a medical or dental practice in a short amount of time if it treats a significant amount of Medicaid patients. And in many situations, there are many practices that have 70–75% of Medicaid patients that they treat in the scope of their entire practice. In the sole OIG CAF payment hold process, the administrative law judge, in the sole case that went before the administrative law judge at the State Office of Administrative Hearings, it was found that there was insufficient evidence of fraud or willful misrepresentation by the provider. And when the SOA judge's proposal for decision was returned to HHSC's administrative law judge, who has delegated the responsibility of entering a final order for cases referred to SOA under current rules. But as I understand it from the testimony given by Mr. Stick, the delegation has now been removed and returned back to the executive commissioner, if I understood him correctly. The HHSC judge entered the final order as required. She didn't sit on the case. However, she was acting in a ministerial capacity on behalf of the agency itself, and therefore her duty was simply to enter the final order. However, the OIG challenged the HHSC judge's entry of the final order in an attempt to overturn the findings of the SOA judge, who actually heard the case. The final order was inexplicably put on hold for months until the final decision was once again affirmed. And my understanding is that HHSC judge has now left the agency. It has led to concern as to the independence of the HHSC judges and the HHSC contested case process. An independent and fair contested case process is essential to constitutional due process and is the very reason why the State Office of Administrative Hearings was formed in the first place. I believe those concerns are valid and applicable to the enforcement of OIG contested cases, and that the best route for protection of due process rights and a fair and impartial hearing would be to give providers those rights and to have their cases heard by the State Office of Administrative Hearings. I would also agree with Mr. Canales' assertion that under current rules, it is solely up to the agency's discretion to determine whether or not a case is sent to SOA or is heard by HHSC Appeals, and they have always had a policy where they would intend to send those to the HHSC Appeal judge wherever possible. So in order to ensure fairness throughout the entire process, I believe also that it is necessary to consider having a panel of independent experts review the Medicaid cases after the investigative process and before the initiation of prosecution to ensure proper sufficiency of the cases. That's not contained in this bill, but it is something that I also support. I think that the bill can go even further. I think that House Bill 1536 will help to ensure that the OIG can continue its duty to investigate fraud, waste, and abuse, while also ensuring providers that the enforcement process will be fair and impartial and protect due process rights. That's the end of my testimony. If you have any questions, I'll be happy to help.
Well, what is your feelings or your thought or your observations about what was going on here? I know the prior witness called it an agency run amok. I mean, you're in the middle of it, so you had
I was in the middle of it.
What's going on?
Okay. I think, honestly, from my perspective, I think the agency is afraid of having to justify itself. I think that one of the interesting things that happened in one of the exchanges from Jack Stick is that when he was asked about the number of dollars, I think, that the agency was brought in, or something to that effect, he referred to it as the identified payment or the identified amounts. That's probably not the questions you want to ask or the answer you want to hear. You want to know how much they actually recouped, not how much they identified. They can identify a very large amount. That doesn't mean they've actually brought any of those funds into the agency. And so there's been a long-held problem with regard to the performance of the agency, the OIG, as to whether or not it was actually justifying its existence. And so part of the focus, and it's well understood, an agency should try to justify itself if it can, but there was a hard-line approach to make sure that they were aggressive in terms of recovering a sufficient amount of dollars to bring back to the state to say that they could justify the agency continuing in and of itself. That was clear.
Okay, but even if, and we'll call Mr. Stick up in a minute, and so Jack, if you could get those figures, how much money you've recouped, not accounts payable, okay? But by the same token, I guess the concern would also be that they're in a position to hold payments, right? And that's what to Mr. Canales' point, in part, you hold up payments, right? Or you just put a physician in the position that, number one, if they've got a significant number of Medicaid patients, they can't keep going, right?
Correct.
And number two, they're facing a significant, they're looking at an agency that's saying, look, we're going to charge you with $1 million, $2 million, $3 million, $4 million, whatever it is. And you just put that person in a very tough position as to what course of action is left for them.
I discussed informal conferences a little bit more in the full testimony. I didn't get into it here, but one of the problems that I would say from a provider's point of view is that once they've been put into the process of having a payment hold, and if they have a significant amount of Medicaid in their practice, they're on a very tight deadline. They have to try and find a way to make sure that the money gets turned on. And I think that one thing that wasn't clarified earlier was that when a hold is put in place, it basically is a 100% hold of all Medicaid funds flowing into that particular practice. It's not limited, although they can ask for financial burden. That in practice is rarely given, or at least it was rarely given while I was there. It was basically understood that there would be absolutely no exceptions made, unless, of course, there was something extraneous that just simply came up to the IG and he made a personal call on it. So that was very rarely done. What I can say is that it was very tough for a provider to go into an informal conference facing the end of their practice and then be presented basically with an amount that they were told that they would be willing to settle for. My experience is that they weren't informal conferences weren't as focused on the evidence in the case or in trying to resolve it as much as it was making sure that we were clear with them about what amount they needed to pay of the total amount that was identified and that they owed. And so you basically have someone coming into a conference that basically is under the gun. Their Medicaid funding has been shut off. Their business is going down. They're being told, you can pay, this is the amount of money we've identified, however you can pay this amount and we can settle it earlier. But usually the amounts that they were given were still into the millions, and for most people it just simply wasn't practical.
But they're not getting the money, so what was happening then? At that point, what happens with the doctor?
Well, I don't represent the doctor, but the doctor simply has, if the doctor has sufficient flow, then they can survive. There are some circumstances where the providers may have to go out of business if they can't maintain enough financial flow through the practice to make sure that it's maintained. And part of the concern, which I sort of touched on a little bit earlier about making sure that the process itself is sensitive to the needs of the program, I think that you have to be very careful that if you're going to put these providers out of business and using the credible allegation of fraud, your level of proof is extremely low. So if you're going to put these people out of business, you have to be concerned also with where do the recipients go. You lose the providers, you lose the recipients' ability to be treated by a doctor in their particular area. The agency is now stuck with having to find out how they're going to address all of these recipients that have now lost their provider. And I'm aware that in prior hearings, I believe that they testified that they had some mechanisms in place to address those particular recipients that were without a provider, but in fact they didn't. That was a misstatement that they made, and a lot after the fact, a lot of the agencies were consulting between each other to try and figure out a way of how will these recipients find a new provider in those circumstances where a particular provider was put out of business essentially, or decided to leave the program.